People v. Spirito.
Good afternoon. Excuse me. Good afternoon. John Sarando, Syracuse. On behalf of the appellant, I would request 3 minutes for rebuttal, Your Honor.
Yes, sir.
This is an appeal from a memorandum and order of the Third Department affirming the conviction for the crime of criminal possession of a weapon in the third degree, illegal magazines, following a guilty plea, which followed a suppression hearing, which followed a search by parole officers. In this case, it's our position that, quite simply, the mother's call and the supervisor's call were unsubstantiated hearsay under the Leica decision. And therefore, once the suppression motion is made and there's a hearing, the burden is on the prosecution to prove the sender's information. In
By
this
what
case,
standard, counsel? What standard do they have to vet the information? Is it Aguilar-Spinelli?
they have to vet the information to show the court that there was reasonable suspicion to do what they did.
But isn't the Huntley test, these are parole officers, they're searching a parolee's house, they have information from his mother, a person calling, claiming to be his mother, they know the mother lives in the residence, claiming to have seen a photo with parolee with a gun, and we look at Huntley and we say, okay, parole officers, there's a standard clearly articulated in Huntley that it's related to their enforcement of the parole conditions. Why isn't that it? Why do we have to get into anything else?
It's not a reasonable search under Huntley, because Huntley indicated that the parole officers, and Judge Jones indicated that the parole officers in Huntley were not searching for contraband or evidence to prosecute the individual for criminal activity. So I think that's why you need to show, nobody saw the picture that supposedly started the whole ball rolling. When you look at the, I think the one case we found, the Miller case, federal case, where similar fact pattern, where the mother called and said, I think my son is selling drugs out of my house. The mother provided the tip. The parole officer who got the tip searched, and they both testified at the hearing to justify the action. In this case, there was no evidence to justify the action.
But even under Aguilar-Spinelli, it seems like it would be enough. I mean, you have a person known, the mother saying, I have information based on a photograph, which is evidence that my mentally ill son has a gun and I'm concerned. Like, what would you have the parole officers do at that point?
No, it's not the parole officer that I'm complaining about. It's the people. The people didn't present any evidence at the hearing to show. How do we know that that was actually the defendant's mother that called? How do we know what the picture portrayed? Could it have been a picture of a toy gun? Could it have been a picture of a real gun? That it was a failure of their proof at the hearing that should result in the
There are
suppression
any
of this
reasonable
evidence.
inferences that can be drawn favorable to the people's argument here? Anything that can be drawn?
From their evidence?
Yes.
No. The Third Department went to great lengths.
How about the mother knows what her son looks like, so probably knows that the photo is of her son?
How do we know it was the mother?
She gave consent to come in, and she's there when they come in?
But the guy that came in didn't talk to the mother. We don't know it's the mother. We don't know what the...
So what were they supposed to do? you don't think there's an inference that the supervisor knew the voice?
They should have presented the mother, the picture, and the supervisor,
If she didn't have the picture anymore?
whether she could explain what the picture was.
Mm-hmm.
But there's no evidence of what the picture was.
Well,
was no-
she described what she saw to the supervisor, yeah?
She said, no, we don't know.
A picture of my son holding a gun.
A picture of my son with a gun.
Okay,
That mean,
with a gun, okay,
But-
that's fair.
she should have testified. I think the problem you have is what happened in county court and what happened
Well,
in
the
the
parole
third
officer could have
department.
gone at any time to the house. Do you agree to that? Without a phone call, could the supervisor or the parole officer that morning had said, you know what, I'm going to stop by?
They can always stop by.
Yes, okay.
However,
So now they have a reason to do it in this moment.
in this case, they were not, there was no warrant. He was a model parolee.
I understand, but you already said that they could have gone anyway. Even without a phone call, they could have gone to the
Except-
house.
Except in this case,
Okay.
they went there to look for evidence of a separate crime or a separate specific violation. That's the difference. That's where the reasonable
Do they have a
suspicion comes in.
I thought they always
Responsibility?
visit to look for violations.
Pardon
Aren't
me?
they always visiting to look for violations?
I
Aren't
didn't-
they always visiting to confirm that a defendant is in compliance with their parole conditions?
Yes,
Is that the point of the visit?
yes.
And did they have a responsibility based upon the phone call, knowing he lived with his mother, to go to that residence?
I think we're talking about two different things, Your Honor. We're talking about what happened before we get to county court and what happened after we
So
were
your
in county
complaint
court.
is the proof.
The proof, there was no proof. That's the problem.
So, and since it's the mother's phone call that got this whole thing rolling, you're saying that the people had the obligation at suppression to somehow establish that the call that came in was in fact from the mother?
Yes.
And not some random person saying that they were the mother?
Yes.
And what's the, I think you might have been asked this question before, where does that requirement come from?
When you look at the Leipka case, it says that the bulletin or the information is unsubstantiated hearsay. And once, which the police are allowed to act on. That was the bulletin from Pennsylvania, I believe, that came up from to
But
New
these are
York.
parole officers who can go at any time. They didn't need the phone call. They could have gone anyway.
But the record that the people relied on was the call from the mother, the picture that the mother said she saw, nobody else has seen, the supervisor who said, I talked to the, who told somebody he talked to the mother. He didn't come in the court to tell us anything either. I think you have to look at it in terms of the way they presented their case. The way they presented their case, I submit,
So
was
if I'm
improper.
understanding you, in terms of what should have happened, put aside the hearing, that when the supervisor gets the call, they should have done something at that point to confirm it's the mother and to get a sense of what photo she's talking about? Is that, at that moment, is that your position? That's what the
We don't
supervisor had
know-
some
we
burden to
don't-
do that?
we don't know what they said. It's, as the Leipka case says, you can act on the unsubstantiated hearsay, which is proper for the authorities to do. Then the question becomes, when you go into court, you've got to prove that the sender's information was correct for your reasonable
Is
suspicion.
that a parole case?
And,
Is that a parole case?
no,
Yeah.
no.
Yeah,
That
and
seems
it's,
to me the
yeah.
difference here,
But
right?
I don't think it's different because.
And that's true of Miller also. Miller is not a parole case, right?
The Miller, the federal
Miller.
case, yes.
Oh, not the federal
De-
case,
definite.
the state Miller case.
The state Miller,
Anonymous tip, guy in a red what is it, a red, gray jacket and a red hat with a gun, that's the anonymous tip?
No, the Miller I'm talking about is a parole case where the two people, the same facts pattern, the two people testified.
So the fact that he's a parolee, in your view, has no bearing on the analysis?
When you get into court,
I'm not sure what that means. So you have no quarrel with what happened at the scene? Your objection is simply?
what you have,
Well, maybe just, do you have any objection to what happened at the scene?
they went there, the way it was proven in court was that they didn't have reasonable suspicion to search, okay? There's two analogies when they're acting, when whoever law enforcement is acting on a police, a bulletin that they received, information that they received. And that bulletin is hearsay. And it's unsubstantiated. But when you get into court, you've got to substantiate your information. That's what we're saying, that you have to substantiate your information, especially in the case where they were searching for contraband or evidence to prosecute for criminal activity, which they weren't doing in Huntley. And Huntley had a warrant, McMillan had a warrant. This gentleman did not have a warrant out for him. And I think that you have to look at it as what they did in the court. And I see my red light is on, so I don't want to give you probable cause to do anything. So,
Thank you.
so I will sit down.
Good afternoon. May it please the court, your honors. I'm Cheryl Mancini for DA Kirk Martin from Tioga County. And
With respect to the complaint that I believe I heard from the defense, is that arguably what happened before everybody went to court, the parole officer was acting and performing duties. But then when you went to the hearing, you were supposed to present more than you did.
I think that my opponent's argument would be stronger if the defendant did not live with his mother. So the mother wasn't required to testify at the suppression hearing. Hearsay is allowable at a suppression hearing. And parole officer Bolden, who was the defendant's own parole officer, who was the subject of this whole case, he was the one who testified. And he actually said it best on page 81 of the record. He said, being any time that a parolee, that there is information, may have a gun, it is taken very seriously. So we try to get there as quickly as possible. And based upon the defendant's mental health designation, he had the highest mental health designation. It rose the level to even higher. And that sums up this whole case. I mean, the defendant signed his conditions of parole. He gave parole unrestricted access to search his house. And
Well,
he
we've
lived-
said that the conditions don't really extend beyond what can be done constitutionally.
That's
right?
correct, but the question, according to Huntley, and in this case, actually, my opponent talks about, I think it was Leipkema. This case is really textbook McMillan. I mean, in McMillan, it's the girlfriend who's calling about her son in the car with the defendant, and she's frantic. Here, we have the mother calling because she sees her son with a gun, and she's extremely worried.
And even McMillan, I think, was a police officer, right?
Right, and here, I mean, he's on parole. It's the defendant's own parole officer who goes. He's been to his house 6 times before. You know, it's an approved residence. He knows he lives there with his mother
So
and
what's the
stepfather.
standard you would say applies here?
That it's a question of it's a mixed question of law and fact. It's very fact-specific here, and that
But
they
what do they
have
have to show?
reasonable suspicion, that the search was reasonable based upon their individualized suspicion because they had a call from a known person.
And where do you find a reasonable suspicion standard? Because I don't see it in Huntley for a parole officer.
That it's rationally and reasonably related to their
Right.
duties as, the parole officers have a dual function. They're protecting society and they're protecting the defendant. helping him reintegrate into society.
Does the dual function create dual standards? Because my understanding is the actions of a parole officer under Huntley have to be reasonably related to their parole function.
Not reasonably based on some suspicion from outside sources. And then I think there's a second part to Huntley, which says the conduct must also have been substantially related to the performance. So rationally and reasonably related to the performance.
Right.
And then the particular conduct substantially related. Where's
Both of
there's a
those here.
reasonable suspicion in there? I haven't
Well,
found it.
it's more the rationally and reasonably related, which it is here, and then that the actions of the parole officer were substantially related to his duties, which they were. So that's really the standard
So
you're
does
looking at.
it, does it even matter? I'm over here. Does it even matter? That's a little bit of the kind of questioning I was asking your adversary. Does it even matter that the mother called? Can't they just go at any time?
Absolutely. And I think the opponent talked about earlier, Aguilar Spinelli, which we would say doesn't even apply here. It was the mother. They knew that the defendant lived with the mother.
Okay, so you described the mother as a known person, and I take it that your adversary is arguing that there was no way to know whether the person who called was in fact the mother, and cites cases about anonymous tips. Is there anything in the record that shows that they in fact knew the caller to be the mother, or are you asking us to infer that? What's your
I mean,
response
it's
to that?
sort of by inference because they knew that the defendant lived with his mother. They had been to the house. They had been to the defendant's bedroom. They knew it was the mother and stepfather who lived there. Is it in the record how many times the defendant ate with his mother or interacted with his mother? No. But when you look at the totality of the circumstances and the,
But that's not really the issue. Your adversary is not arguing that the mother didn't know who her son was. Your adversary is arguing that whoever at parole picked up the phone didn't know who was on the other end of the phone.
actually, at the suppression hearing, the officer testified, senior parole officer Kunzman got a call from the defendant's mother.
Did Senior Officer Kunzman know that it was the defendant's mother? Did he know her voice?
There was nothing in the record to establish.
And that, I
Correct.
think that's really what he's arguing. They got a call, but they're not verifying who the caller was. And my question, I think a lot of our questions is, do they need, is there something in the law that requires them to make some sort of verification? Or are the responsibilities of a parole officer related to Huntley such that they can say, yeah, well, that's a concern because this guy's on parole, so we can go to the house and take a look?
Exactly. It's the latter.
second
It's the second, yeah, exactly. And it's also the fact that the mother didn't call 911. She didn't call the police. She called parole. She knew her son was on parole. So all the inferences point towards that it's actually the mother who made the call.
So to be clear, in response to me before, I think you took the position that they didn't need the phone call. But if they need the phone call, or once they got the phone call, it would not be measured by the same standards that one would measure an anonymous tip anyway, given that parole officers could go at any time.
Exactly. And they'd been there 6 times before to his house. So, and I think my opponent also had an issue that maybe they didn't know when the picture was taken, or was it a text message or a Facebook picture. I don't think any of that is really important when you have someone who has the highest mental health designation, according to the Department of Corrections.
If that wasn't the case, would it then matter?
No, I don't even think it matters anyways. They have reasonable suspicion that they have a parolee who has access to a gun, and they wanted to follow up on it.
And what if it had been not the mother, but just somebody calling in and saying, hi, I don't want to tell you who I am, but I just saw this guy on the street with a gun?
I think if parole didn't go and he had the highest mental health
And
designation,
suppose he didn't have that. Suppose he's just a regular parolee.
in this day and age, they'd be remiss if they didn't go. They signed the
And,
conditions of
well,
parole.
it's not a question about whether they could go or not. It's a question about whether you have to prove anything at the hearing. Is it sufficient to just say, we didn't have to have a reason, but it turned out that some anonymous person called, and so we went to check it out?
Well, then it boils down to, was it substantially, the second part of Huntley, was it substantially related to their duties? And I would argue, yes, it is.
Well, if the report is a gun, and I assume he's got a no firearm, right?
Exactly. So if there's no further questions, thank you.
Just briefly, obviously, our position, they have to present more than they did, and everybody keeps talking about the mental health condition, but nobody indicated how that specifically related to this complaint or this information. And I think when you look at the appellate division decision, they went to great lengths, the majority, to bootstrap the mother's information on information that is not contained in the record. And the mother wasn't spoken to, I think, according to page 89 of the record, until after the search was conducted and anything like that, so, when they were at the house. So there was no corroboration that this lady even called. So we submit that there was not reasonable suspicion to do what they did, even though the defendant was a parolee, and the matter should be reversed. And some of the things that my opponent was getting into almost the inevitable discovery area, which under 470-15, I think, is not available in this case. So we would ask that the decision be reversed. Thank you.
Thank you.